He's removed the chairperson of the Electoral Commission and her 2 deputies, following various petitions sent by separate petitioners. And this followed the Chief Justice establishing there was a prima facie case to warrant the setting up of a committee to look into the matters. Tonight, we ask, is it a question of law, a question of politics, or a question of both? I have some fantastic guests to help us plow through these murky waters. Don't go away. So tonight we've invited 2 erudite legal practitioners. Oppong is not a stranger to the city brand. He was one of the first lawyers we had on our S1 radio show, A Question of Law. And he's shown tenacity to come back. These days, he dresses in fine clothes, nice pink shirt and a bow tie. Lawyer Oppong, it's great to have you. Good evening.
Good. It's always good to hear your tribute to us you are alive. And when you are dead, you won't see
it's more an accolade than a tribute. We also have lawyer Martin Kpebu, who's also a strong lawyer. He's made his mark
an eminent lawyer
in the human rights space of law. And we've interviewed him on many issues to do with human rights and public interest law. He will help us with his views as well. Martin Kpebu, welcome to the show.
Thank you, Ben.
Great. So don't forget our hashtag is point of view. Before we get into our discussion, we want to show you briefly the government of Ghana's narration of the events. Information Minister and Presidential Spokesperson Mustafa Hamid last week spoke to newsmen about the president's reasons for taking the course of action he did.
The chairperson, Charlotte Osei, and her 2 deputies, Amadou Sule and Georgina Opoku Amankwa, were indicted for infractions such as procurement breaches, wrongful payments of official funds into private bank account, among others. Here is Information Minister Dr. Mustafa Abdul Hamid.
The committee found that she misbehaved, and misbehavior is a quotation, that, quote, she misbehaved in awarding the new STL contracts. It further held that she, quote, showed sheer incompetence in the manner she handled or conducted the award of new STL contracts, in view of her experience with the initial STL contracts, which were abrogated at her instance, unquote. The next step that the President is going to take in respect of this matter is to forward this report to the Attorney General. It is the Attorney General who basically is in charge of legal matters and of prosecutions and issues of the sort. So the Attorney General will study the report by herself, and I'm sure in due course she will report to the Ghanaian people the series of measures and steps that she will take.
So that was Mustafa Hamid with highlights of the reasoning. We have a lot of questions tonight. How unprecedented is this action by the president? Did the president really have no choice? How fair was the Chief Justice in determining that there was a prima facie case against the chairperson and her 2 deputies? How competent were the petitions sent? And what does the latest legal challenge put up by a private citizen do to the procedure of choosing a new chairperson of the EC? These are some of the questions I have for my guests. Gentlemen, so welcome again. In terms of what has happened, in a sense, you can say this is normal because this is not the first time somebody at the level of a high court judge or higher has been removed. But in terms of having a sitting chairperson of an electoral commission removed in this manner, it certainly is unprecedented, yeah. It certainly is.
Well, thank you very much. But on my part, I think it may be unfair to just highlight the removal of a chairperson alone. And I have been at pains to highlight that even the word chairperson is not used in the Constitution. This is chairman, male or female. So I don't think we should pretend to espouse better law than those who made it, thought it wise to put it. So there's nothing like chairperson in the Constitution.
We are just being gender sensitive.
Oh, well, I mean, those who made the Constitution in 1992 and became effective in 1993 knew better than us. We shouldn't now think that all of a sudden, within 20 or 22 years, or just a few years.
So I stand corrected, Chairman.
No, not just you. Even in the report, the SF that we have, we see chairperson. There submissions of the lawyers, if indeed they are their submissions, they use the chairperson. But I'm saying that I would rather go by the term used by the drafters of the Constitution is chairman. And they knew that one day a female can be a chairman of Electoral Commission. But also that we shouldn't then concentrate on whether chairman or chairperson. There are 3 persons who have been removed from office. And I think it's important that we highlight that fact. They all deserve to be highlighted in terms of the petition that was brought against them. Now, in my view, 2 outcomes was possible only. And one was that the petitioner or petitioners who brought the allegations against them, I think 2 different petitioners against 3 sets of people, each of them expected to win. And they all won. And the respondents also expected that their petitions would be dismissed so that they will continue doing their work. But they also failed. So the idea that we should concentrate on only the issue of why removal will also discount the importance of the petition being filed in the first place. These are people, quote and unquote, workers who are able to, and another person who is not a worker but an quote unquote ordinary Ghanaian will think that people in official powerful positions, I mean, these are people who, by their declaration, a person can become the first person in Ghana in terms of Article 57, the president and members of parliament. So for them to be bold enough to believe in their conviction that they have engaged in acts that may be contrary to the expectation of competence, and that will also, if proven, will establish a case for stated misbehavior. And for them to be bold enough, especially the gentleman who is, or at least at the time, and those others employed, to take their bosses to go through such strenuous judicial processes, be available to be examined. I mean, you find very few Ghanaians who are bold enough. Usually it is when we are dismissed from work, then we start making allegations against our bosses. That these are people who are still in employment, they make the allegations, their bosses against whom the allegations are made continue to be their bosses. Remember, in the case of Lori Talamte, she was removed whilst the committee was doing its work. In this case, they continue to supervise them, and we should also commend the bosses. Other bosses could have also victimized these persons. So I think in the same vein, we have to commend the 3 persons that in spite of the fact that your subordinates have brought you before such a committee to go through such process, which will, the end product may be for you to lose your job, they also then behave quite correctly in my view, and not.
So I get your clarification. I was trying to ask unprecedented in the sense that in my lifetime, this is the first time a chairperson and her deputies, or chairman and deputies, have been removed while in office. So I was seeking just your opinion on whether in our constitutional era this has happened.
Well, let me come to that. I'm saying that's
what I wanted.
It is not unprecedented because there are precedents. Because the provision under which they are to be removed, and they are removed, have been applied severally against judges who have been removed. And Lori Talamte's case, you know that in some other countries, the position of a person in charge of human rights there's more precedent placed on that position, maybe even than an electoral commissioner, because in those countries, UK, you wake up, you go for election, you may not even know that they are conducting election. So for the person in charge of human rights, and that is one of the eminent human rights lawyers, to be removed, in fact suspended whilst investigation were going on and then removed, it was the highest of recognition given to...
So in terms of law, you're saying if an NCCE boss, a justice of the High Court...
No, Shrike boss.
Or Shrike boss, I'm coming. Because don't forget that one Dr. Oppong was also removed.
Yes.
You're saying that legally, these things are same. So it's not unprecedented legally. But my question is political. Politically, Martin, this is unprecedented, is it not?
Yes, I see where you're coming from. When it comes to the EC specific. Yes, there's a point, and most especially because we have a certain regard for our elections. You see, usually our elections, some have described it as a festival, others say it's like a war. So I kind of understand where you're coming from, and I understand where senior counsel is also coming from. They're coming from different perspectives. Yeah, so to that extent, considering that the elections are like the heartthrob of our democracy, to remove the chairperson of the EC and 2 deputies is such a quantum, you won't call it leap, but that it's such a momentous occasion. Yes.
So don't forget, I asked 5 questions at the beginning of the show, and I want to frame the discussion around that. So first question has been answered. You are saying legally it's not unprecedented, but politically it's unprecedented.
Exactly.
My second question, which is a simple question, did the president have any choice in the matter? I'm sure that's a very simple answer.
Yes, better, because when Anas called me, I was like, Bernard,
simple questions. So I'm asking simple questions. The president have a choice in the matter?
The president didn't have a choice. The
matter.
Constitution makes it clear that when the committee is done, and perhaps maybe the name of the committee is misleading us. You see, in the Constitution, a committee of inquiry has a similar status as a commission of inquiry.
Good.
So perhaps that should we should begin to use that language so that we'll see. So the committee is not just any committee. It has that stature that a committee of inquiry is this also has the same standing as that of a commission of inquiry.
Good.
And also the effect of the findings are that they have the weight of the judgment of a high court. Now tell me, in this country, do we toy with judgments of the high court?
No.
We give judgments of the high court the greatest esteem that we can master. So perhaps if we begin to add these other ways of analyzing it, we will see that effectively that was the High Court speaking, though we know that in this manner is being constituted differently, made up of 5 persons. So from the Constitution, it's crystal clear that when the committee is done and forwards its findings to the Chief Justice, who also forwards it to the President has no option. He goes by what is in it.
Yes. So you've made 2 points. The president had no option, and this is not just a committee, but it has powers of a high court.
Yes.
So we can see this as the judgment of a court.
Exactly, exactly. And since we don't toy with our high courts, we've always regarded our judiciary with the highest esteem that we can master. That's the same thing that we should do to this judgment.
Are you ad idem on this?
I fully agree, except to just add a few. Indeed, if the president had failed to implement the recommendations, and this is not the other kinds of recommendations that by their nature you have an option not to even comply with it. If he had failed to do so, a person could, under Article 2, go to the Supreme Court for the Supreme Court to compel him, or as the case may be in the future, her, to perform those functions, implement it. And if you fail, under the Constitution, it can be a ground for impeachment.
Exactly.
If you are president or the vice, and the rest of us, you and I, you can suffer imprisonment for 10 years, and also after the 10 years, you suffer a disqualification to hold any public office for another 10 years.
Good.
You understand? So, as he said, the president has no discretion. If they had said that the petition has failed, the person should continue to perform their functions, the president shouldn't have valued it.
So this question
is a clear case of enforcement of the rules.
Let's move to the next question. This question is a simple question.
Yes.
The third question is twofold. How competent were the petitions sent? And inherent in that question is, how fair was the CJ in determining that there was a prima facie case to warrant the setting up of a committee? I hope the question is clear. First one, don't forget, Tadiosori in challenging said there were a lot of defects procedurally. He said number one, there was a problem with the competence of the petition itself because it wasn't signed, its validity. Number two, it was fraudulent because there are people whose signatures were there who are not alive. And number three, it was done in bad faith because there was a video that showed that people were planning to do such a thing before it even got into a petition. All those three were overruled. But my question to you is, independently, reading the petition and listening to the arguments of Tadiosori, are there any merits to his claim that the petition was incompetent, fraudulent, and brought in bad faith procedurally?
Well, if you want me to start, well, I would say, you see, that alone should tell you that this was not a joke. It was a very serious judicial process that went on. I mean, the lawyers for both the petitioners and the respondents, these are lawyers that in our current situation or current time, they are very eminent lawyers indeed. I mean, when you read their various statements of case or addresses, you will realize that they espouse competence in terms of the legalities and otherwise of all the principles that they could marshal, and especially my good friend Tajo Sori's position. These matters, don't forget, some of them were already addressed by the Chief Justice. When the Chief Justice established that there was a prima facie case, what constitutes a competent petition was addressed by her. And it was on that basis that out of the 27 against the chairman of the Electoral Commission, I think only 6 were recommended for further
So
investigation.
she dropped 21?
Yes.
To
so
tell you that she didn't scrutinize it?
Of course, yes. And
But
these matters were raised. But see, on the issue of signing or non-signing of an instrument, a legal instrument, the Supreme Court in a recent case, this is F4 versus that once the conduct, by the conduct of the parties, it tends to emphasize a particular state of affairs, notwithstanding the non-signing of the document, a court of law can act on that instrument.
Let's even add Wayomi. So
Yes.
because this is a process,
Oh,
Martin
yes.
Amidu didn't sign one of the processes.
Fantastic.
The Supreme Court gave. So there's a binding Supreme Court decision.
What
that
about
if
the
it
fraud claim?
And you see,
That was a dead man's signature. You put a dead man's name there.
well, I mean, of course, I don't know about that. But
No,
the
you know
point-
about that.
No, my point is...
Because
listen,
you can't say you don't know about that.
I
You
don't
know
know whether
about-
the person... Did
No,
the-
the witness admitted that the person is dead.
but the committee, in spite of that, the committee...
Yes,
So
but that's
there's
what I'm
what we
asking
call
you.
the
You see,
doctrine of severability. You say
I
it
know.
can be
I have spoken
Excuse
with...
me.
I have spoken...
I know what the committee said.
Okay.
You're a lawyer of high repute.
Okay.
I'm calling to ask your opinion. Forget what the committee said. I'm not here for you to tell me what the committee is saying. I'm saying that if somebody is dead and you put his name on a petition, is it reasonable to say that that was not fraud?
Well, let me tell you also that I have also found out, and what I heard was that from one of the lawyers who acted for the petition, is that the person died in the course of the proceedings. He didn't die before the commencement of the
You have heard.
proceedings. That's
As
what
a
I
ma-
have heard.
So what's the date?
As you have also heard.
What's the date of the person's death?
I mean, you haven't told me.
No,
you haven't even showed
but
me
Bernard, there is what we call- let me-
a copy of death certificate.
Yes.
But you have believed in what you have heard. And
Yeah.
I'm saying that
You also believe that he died in the course of the proceedings?
because I have been told by one of the persons whom I can trust, and I can found a decision on what he has told me. And I'm saying that, and to the extent that the committee rejected that argument, should tell you that then there was no proof.
No, but if the committee's views are sacrosanct, we don't have to have this program.
No,
So
Bernard.
I don't want you to use what the committee...
No,
I am
but
asking your
so
informed
you
opinion.
rather rely-
No, I'm saying that don't tell me that because
Okay.
the committee has done it is
What
correct.
you are just getting me wrong. What I'm saying is that
Yeah.
you said you have heard from one of the lawyers for one of the respondents
Yes.
that one or some of the petitioners was dead
One,
at the
at least
time.
one.
Yes.
And I'm saying that I have also heard from the lawyers of the other side
Now, he died
that
in the course of
he
the
died in the
process.
course of the proceedings after
Yes.
the matter has commenced. And in law, generally what happens, Martin will tell you, is to file for an application for substitution.
No
But
problem.
if that application is not filed, it doesn't mean that
Okay.
the other petitioners cannot get a remedy from the court.
Okay, Martin, what do you make of the procedural issues raised by the respondents to the petition?
No, number one, I'll tell you what, that's within, I made that remark while Senior was talking. Under the law, when you fail to sign a process, you present to a court, okay, depending on what it is. Since it's not an affidavit, it's not fatal. You see, it's a petition which should be signed. We have a Supreme Court decision where the Supreme Court has looked at such a matter and said that failure to sign doesn't make your process void. That's why I say in the Martin Amidu, the famous Wayomi case. Yes, it happened. The Supreme Court looked at it. And that wasn't even the first time. They say Martin Amidu, 97, 98. There was another case like that. He didn't sign. The Court of Appeal looked at it and said, no, we will save the process. So as far as I'm aware, look, long before this petition came, there were decisions of the Supreme Court and decisions of the Court of Appeal where failure to sign a process did not result in the proceedings being a nullity. If it were an affidavit, you see, an affidavit, you are swearing on oath, then that's when, if you fail to sign, then what you've presented is void. So that one too, there are court decisions. But this one is a petition. When you are signing a petition, it is not an oath. You are not swearing.
Okay.
You see, so that's a distinction. So for me, any arguments about failure to sign a petition don't sway me, to be very objective.
What about the bad faith claim?
Yeah, the bad faith claim, you see, these matters, let's see it this way. Naturally, you have the other side, but let's look at it this way. The fact is that book no lie. This is a simple way I'll look at it. Book no lie. The point is, when matters came to a head, for those contracts that required PPA approval, that's Public Procurement Authority, was there any approval? Nothing was sought. So, I mean, and that's not, no evidence was provided. Let me repeat, as far as I'm aware, when matters came to a head, when it had to be proven whether the Public Procurement Authority's approval was sought, there was none. So issues of bad faith, well, you know, this world...
The bad faith was in relation to the fact that there was a certain audio tape
yes, that's
of a recording between a journalist and one of the sub-commissioners,
yes,
where the idea that there was a plot to have Charlotte Osei removed was revealed.
Yeah, that's why I say it cannot nullify it. You see, let's look at corporate
They went
Ghana.
through the process.
Yes.
And whether they conspired or not.
Yes.
That doesn't vitiate what is
It doesn't.
At all,
fantastic.
at all. Let's look at the substance. That's why I said in one sentence, Bernard, book no lie. The contracts that the committee referred to, where is the approval from
Great.
the Public Procurement Authority? Just one sentence. If you have the approval, then let's move on. If there's no approval,
Great.
then the law takes its course.
This is the point of view. We're live on City TV. My guest, Martin Kpebu, who's a human rights lawyer, and Oppong, a private legal practitioner and a law lecturer. We've asked 3 questions which they've answered. First question is essentially, how unprecedented is this? We've also found out whether the president had his hands tied. In the affirmative, they've answered. And also whether the petition was competent. When we come back, we have more questions. Was the CJ fair and consistent in her determinations? Because people have pulled up the Ajay Chum versus Attorney General and Bright Akwete and statements she purportedly made and whether she's being consistent. Other questions people are asking is, in determining misconduct, was she dealing with a civil or criminal conduct? And the other questions about the Fafali case, which have been brought up. We'll ask our guests these questions and read your comments as well. This is the point of view. Don't go away.
Wherever the weekend sporting action happened, we will bring it to you here on Scorecard. Every goal, every dunk, every punch, the winning strides, and the winning volleys.
Come, international media. He said, look, wait, sit and wait. Let me have a meal with my people. And I think that's the same cool, it's the same organization he brings to the field every time I've seen him play. He looks to me like somebody who's played over 50 caps already. Okay. But this guy has barely played over 25 caps for the national team.
All of the weekend's action in one place. Scorecard. Every Sunday at 8 p.m. prompt on CTTV.
Spend 30 minutes every weekday catching up with all the trending social media conversations of the day. If you tweet it, we'll read it. We might just even Skype you. 30 minutes is all it takes, so use the hashtag 30minutes on social media to catch our attention. Join the most interactive social media TV show weekdays at 5 p.m. only on City TV.
Welcome back to The Point of View. We're live on City TV, hashtag Point of View. We're on Facebook at CityTVGH. If you're enjoying the show, let's know. There's a lot of conversation going on below the video. Let your views be heard. If you agree or disagree with my guests, we'll be happy to read your comments as well. My Fourth question for the night is whether the CJ herself, in her prima facie determination there was a matter to be heard, was consistent, because I have in front of me in the 2006 case between Franka J. Chum versus AG and Bright Akwete, where a petition was made to remove a Chief Justice. She stated inter alia that it is true that unless otherwise prescribed, committees have the power to establish their own operating procedure. However, the committee envisaged by Article 146 is clearly of an ad hoc nature, and it will be extremely detrimental to the nation to hold that it is up to such a committee at any given time to map out its own procedures. She goes on to say, I seriously doubt that the drafters of our constitution intended any such thing. Moreover, even the nature of the offense for what a justice of the Supreme Court or Chief Justice may be impeached and removed is rather nebulously expressed in this constitution. And then she goes on to say some other things. As they stand, the formulation of these offenses leaves too much room for personal opinion and individual proclivity. She actually does say that the constitution is not intended to provide details and procedural guidelines, but rather establish a framework of the fundamental values and standards upon which substantive and procedural legislation may be, and are expected to be, built for the good governance of Ghana. So her point is that the committee she set up, and this is 2006, ought to have clearer terms of reference, and that we can't rely on 146 for its terms of reference. Yeah. A couple of questions emanate from there. She's been Chief Justice for at least a year. Has she put in place those procedures? Number two, what were the terms of reference of this committee stroke commission in line with the points he raises in 2006?
Okay, so if I may start. Basically, yes, you raise a point about whether we've made any new CI to be able to take care of this situation. As far as I'm aware, no. Coincidentally, about 2 weeks before this decision came, I was having a discussion with another lawyer, and we saw it. So we said, no, we would write to her that this thing should be done. So as far as I'm aware, no, we haven't seen any new CI on this matter. But in law, the absence of the CI doesn't mean that the proceedings cannot be fair. No. There are so many tools, so many aids to interpretation, and so many other ways of going about it. So that's how come they've been supplementing, okay? Yes, in the way they read it, and then, so let's say the prima facie determination. You see that it's not stated how exactly it should be done. But the practice has shown that before the CJ makes such a determination, ordinarily the CJ would ask the respondents to also respond. You say, so that at least the CJ would take those initial response and juxtapose those against the allegations in the petition. Just like when you hear prima facie, meaning the court of law, often that's at the end of the prosecution's case in a criminal trial. And usually if you see that process, by that time, for each witness that the prosecution presents, the accused also cross-examines. So for me, when the CJ asks for the initial response of the respondents and use those to match them against the allegations, I think it's sufficient.
But when she says it's like an ad hoc committee.
Yes. Well, it's
yes,
not because it's not standing. Exactly, it's not a standing committee.
But that doesn't mean it's not fair.
So you see that.
No, but her point was that they can't create their own procedures. The procedures must be procedures we all agree on.
Yes, and that's the point.
But
so
I'm saying that do we all know what procedure they use?
So you know what they do currently? There's another practice where when some go before the committee, they use the commissions of inquiry CI. At least I know that's what our good friend Samson did in the Shraj case. But it's not satisfactory. That's why I said before this decision, we had discussed this elsewhere. And we've actually done a draft. We'll present it to her. Since that was her vision, then maybe she can push it further because she's actually chair of the Rules of Court Committee.
So what's your comment on this?
Well, just to support what he's saying. So you see, and as the general rules of court proceedings, what we call the CI 47, are changing. For example, so now we have what we call witness statement. And in these proceedings, they ask them to file their witness statement instead of going into the box and giving evidence in chief. So they have adopted that, and I understand that they actually agreed with the parties as to the procedure to use. And the parties, in my view, never disputed that or objected to that in another forum. So it means that they submitted themselves to it, agreed that it was fair to all the parties involved, and therefore, having submitted themselves to it, I think procedurally they may not have any complaint about it. If they have any other issue about the substantive matters in terms of the final decision, I think that can be raised.
Let's go to the next question. Was the committee fair? And I'll explain. That's two questions. Did they go beyond their mandate, and were they fair? Because don't forget, the 146 is talking about stated misbehavior and incompetence.
That's right.
Right? A lawyer friend, who knows, says procurement breaches are criminal in nature. So the first question they're asking is, did they treat the allegations as civil or criminal? Because civil, you are the law people. You know that when it comes to civil, it's balance of probability. When it comes to crime, it's beyond reasonable doubt.
You should apply for a certificate.
So the question is, did the committee treat the 6 allegations as civil offenses or criminal offenses?
Yeah, Bernard, once again, I think it may not be fair that we still look at this thing in relation to one person alone. Because by referring to 6 allegations,
no, I we don't have information and any document on the other 2. We can't purport to come on radio or TV and discuss a dismissal for which we have no material. The materials we have all have to do. In fact, the documents that have been released to us have to do with the chairperson. So I don't know why I keep going on to the other 2. I can't discuss what I don't have. So I don't know.
If we had been told from the beginning that we are only going to deal with let's be fair, please.
How does including the other 2 change? I'm asking you specific questions on the basis of what is in the public domain.
Yes.
We can't work with what we don't know.
Please. So first of all, the point is that I am holding the view, and that's why I was invited. I was invited to deal with one person's situation alone. But forgive me, the point really is not about whether or not somebody took a civil proceedings or criminal proceedings. Loretta Lamte's case, the fundamental question was whether or not it was proper for her to have breached the Rent Act. The Rent Act, a breach also attracts criminal sanctions. And so the committee held that for her, a lawyer of that caliber or status, and also whose position is akin to that of a court of appeal judge, not to know or be aware of the fact that a breach of that provision, which will also result in consequences, was unknown to her. And if I may just go on, you see, there are cases and authorities which are to the effect that a judge cannot ignore the consequences of the breaches of the law, even if the parties have not raised it. We don't want to sound legalistic. Yeah. And when your position is akin to that of a court of appeal judge or a high court judge, then these matters must be the first point of call. So otherwise, how will somebody then even say that any of them has engaged in acts that relate to incompetence or stated misbehavior? And so you will see that in both Loretta Lamte's one, and if we concentrate on the Madame Charlotte Osei's or Mrs. Charlotte Osei's situation, they were all both related to the violation of statute. And the court, and they, if you extend it, being justices of the court or persons who are mandated to implement laws of this country, they cannot just pretend not to be aware of laws that are specifically related to their functions. You go to Parliament, you ask for an amount of money, huge sums of money, to enable you engage in acts of procurement. You cannot say...
But I think the question is, when you say stated misbehavior, what does it mean? Because we need to have a working definition for which we can use to treat the evidence.
When you read the Chief Justice's statement or declaration or decision or judgments, she went into details and was at pains to explain these 2 terms.
But did she point out whether you are saying I shouldn't differentiate whether it's criminal or civil?
No, I haven't said that.
I'm saying it's an important question.
I haven't said that.
So in her determination, did she treat the offenses as civil or criminal?
You see, the first thing is about violation of the laws. before then you look at the consequences of it.
Yes.
The violation may carry two things, both civil and criminal consequences. Even under the Procurement Act, you can still be asked to pay for any amount that has been lost to the state as a result or as a product of your violation. That is a
so it's not mutually exclusive. You can have an offense which is both.
You can get a set of facts on which a civil and criminal matter can be founded.
Please, are you in agreement?
Yes, of course, that there can be a set of facts that you can have the civil and then the criminal. Let's take a simple example. If A slaps B, okay, in torts, we'll call it battery. Yes. If you sue through your personal lawyer, you go to court only for money, damages. But if you report that same conduct to the police, they will charge you for assault. Right. And that could have up to 3 years imprisonment. Yes, but coming to say, look, Bernard, to be very candid, the thing about criminal and civil, it won't go far. Look, this is how it is. Even let's start with court decisions. Since the Supreme Court has dealt with such a matter, in the Jechu case, they posed an example that, look, if let's say the Chief Justice were found taking bribes from judges in order to influence how the Chief Justice transfers judges, it will be a proper case for proceedings under 146. Did you hear that? They use the word bribe. The Jechu case, if you read the whole thing, they see that they give the example that if the Chief Justice were found taking bribes from judges so that it will influence how the Chief Justice transfers them, it will be a proper case for 146 proceedings. Okay, so it's been clear to the Supreme Court 2006, so how many years now? More than a decade. That look, calling it a criminal in nature doesn't exclude it from the province of 146. This is what we do. You see, this committee is investigative in nature. It's not just the normal adversarial high courts or court of appeal. No, it's a investigate. So they are not restricted to our everyday adversarial proceedings that you stand here, fight your case, the judge is in the middle. No, this one, they are actually investigating. So if you think you have something that will exonerate you, you come. So let's not unduly restrict them with all the everyday adversarial.
So the other question is, how did the committee prove that there was a breach?
So let's come to this. Apart from that, in the Evidence Act, it says that when you are dealing with a civil case and then you find that there is something that is criminal, all you have to do is to raise the bar to meet the criminal standard. So you see, you are talking about a civil criminal. Yes. So long ago, we knew that you can be dealing with a civil case and criminal conduct will come in. So if criminal conduct comes in, it means raise the bar to prove beyond reasonable doubt.
Because don't forget that she denies all, and that's why sorry, I'm still using her case. She denies all the allegations.
Yes.
So my point is that how the committee have proved.
Let me add, Bernard. Sorry. Yes. You know, we have to also acknowledge the fact that two of the personalities by the Constitution ought not to be lawyers nor members of Parliament. So they are applying, if they may permit me to say so, common sense.
Yes.
And that will also in a way dilute the legalism and the technicalities
so it won't be just
of the others. So these are persons, yes, the other three eminent personalities also live in the society, but they may be influenced by the law and their legal knowledge. But these are quote unquote ordinary persons. We say Timemufo, who just listen to what the people say. It shouldn't also influence them, but they bring their knowledge of a non-legal experience. And so when you look at it, and it is a unanimous decision, that it is not as if a few lawyers have sat down, they have applied legalities, and they've been unreasonable. These two personalities can also bring to bear their non-legal experience. And that is what has also culminated in this whole decision, which is unanimous for 3 lawyers who are justices and 2 non-lawyers, and I'm saying that the 2 could have even dissented. But so far, that is not what we heard. It means that with their non-law experience, they agreed with the 3 experienced lawyers that applying common sense, we also believe that the 6 or the 4 or the other provable allegations have indeed been proved and sustained.
Viewers, we'll be showing you some of the allegations in some infographics on the screen for you to understand some of the things we're talking about. So my guests are 2 lawyers who are really taking us through some school. I've asked about 6 questions already. How unprecedented was this? They've answered it. Did the president have a choice in the matter? They say he had no choice. And then we said how competent was the petition. They say based on the objections raised procedurally, it's neither here nor there. The three objections, incompetence, fraud, bad faith, neither here nor there. Then we asked whether the CJ was consistent and fair in the terms of the prima facie case. They think there isn't too much to say about that. And then whether the committee itself was, what method the committee used to determine that this really meant that the chairperson or chairman and her two deputies had misconducted themselves. And they say, in fact, it could be both criminal and civil. So I think there's a final question we need to get to before I read some questions. But viewers, so this is a small sort of thing we are showing you, a timeline of what happened. So don't forget that there was more than one petition. There were different petitions, and it appeared there were counter accusations which fed into the petitions. So a lot of the information on the chairman came from the deputies and vice versa. So the CJ and the Chief Justice and a committee just used all that evidence together to come to the conclusion. There is a suit. There is a suit by one Fafali Nyonato of Accra. And this is 24th June, I think it is. Not too sure. Yeah, but it's essentially, I have it here, and I'm not sure if it's showing on the screen. Essentially asking that a declaration that a determination by the Chief Justice...
The date of filing is there. I think it's July.
It's July, forgive me. 3rd July. 3rd July. 3rd July. So she's essentially saying that they should determine that the Chief Justice prima facie case is inconsistent with Article 130 of the Constitution, and therefore has said determination. In that determination, she usurped the exclusive original jurisdiction of the Supreme Court. And then she cites 44.2 and 146. A declaration that the committee itself overextended in its, its scope, in what it did. They exceeded its powers. That's what she says. And then she's asking for an honor of the court to declare as null and void the said prima facie determination and then the subsequent report of the committee. What does this mean for the process? Does it put a stop to everything?
Well, Bernard, first of all, I hold the view that, I mean, in a civilized society like ours, whenever there is a dispute or a disagreement about anything that is resolvable by law, you go to the court. Yes. That is the best way to resolve these matters. Otherwise, to linger on, and people can create mischief with it. So whoever is dissatisfied with any legal matter or any matter in the society which he thinks that it is only resolvable in court, and knowing that if it's about interpretation of the Constitution, then you go to the Supreme Court. We need to encourage that kind of practice. That's the only way by which we can develop the law. In recent times, if people had not challenged issues about the right of a criminal, a suspect, or an accused person to documents or data or evidence that has come to the custody of Attorney General, we will still, and some of us will still be fighting in court and always be rejected. So it is important that, after all, justice emanates from the people. Exactly. And let us learn, first of all, also to believe in the independence, not just of the judiciary, but of the judges. I mean, these are judges who have shown over time that it doesn't matter who you are in terms of your nature or your wealth or your position. They can look straight into your eyes and tell you are wrong and do or don't do A or B. So once we have such confidence, then we can go. So we will encourage people like this to commence such actions. After all, when that is done, for nothing at all, it stops people from going into castigating previous judges who have given decisions. You put a stop to the unhealthy public discussions, and we focus. We know
but
that.
Does it mean that the president cannot proceed? Because don't forget, he can't leave a vacuum. They handed over to the director of human resources. I'm sure he was contemplating appointing a substantive head. Does this put a stop to that process?
Well, I don't think so. I think that after all, even this was in the nature of an appeal. We say the appeal doesn't amount to a stay. The president, I think, can still go unless and until maybe a court of competent jurisdiction issues an injunction to restrain him. But even that, there can be a serious issue of whether the court can effectively restrain the president from performing a statutory mandatory function. But that will be until it is determined and the court has rejected it or accepted that argument.
She also wanted Point 4. She wants an order to perpetually restrain His Excellency the President from appointing any person to the position of chairperson of EC until that position has become lawfully vacant in accordance with proper process.
So it cannot be perpetual injunction, because perpetual injunction is perpetual, it's forever. So this may be an interim injunction.
Papa Leonato, we'll take a break. When we come back, I will read
without prejudice, though.
Of course, I will read. I've received a lot of comments on the matters we are discussing. You've answered all my 6 questions nicely. I'll end with the final question.
All right.
But I think you've helped me in your judicious use of time. So when we come back, we will read some of your comments and then ask our guest the final question for the day. This is the point of view. Don't go away.
Wherever the weekend sporting action happened, we will bring it to you here on Scorecard. Every goal, every dunk, every punch, the winning strides, and the winning volleys.
International media, he said, look, wait, sit and wait. Let me have a meal with my people. And I think that's the same cool, it's the same organization he brings to the field every time I've seen him play. He looks to me like somebody who's played over 50 caps already. Okay. But this guy has barely played over 25 caps for the national team.
All of the weekend's action in one place. Scorecard. Every Sunday at 8 p.m. prompt on CTTV.
Well, welcome back. This is the point of view. I have a lot of comments. I'm just going to run through a few of them, and then I'll end with my guests, Oppong and Kpebu. So, Dikadi from Spintex has been at one of the reasons for the line in our national anthem, "Help us resist oppressors' rule," is because of lawyers. Watching how both lawyers are making such compelling arguments, legally but definitely not commonsensical, Mr. Oppong has been engrossed in the recommendations rather than making his independent opinion known. This is Dikadi from Spintex view. Neem Bachona says, "Good evening, Bernard, and to your panelists. It's refreshing to know people have gone to court seeking to set aside the decision to impeach the EC chair and 2 other commissioners. If that succeeds, will there be a rollback to set aside that of the former Shirash Bosch? Grateful if the 2 lawyers can give their thoughts on this interesting times we're in." Neem from Bachona. Gabriel UGBS, Bernard, kindly ask your guests why the presidency called the petitioners to sign if the presidency had no choice. Is this not an interference in the process? I'm not sure it was the presidency that called them to sign, though. Gabriel. Justice Osei Jr., African Economic Dialogue, says, Bernard, I am honestly biased when it comes to women empowerment in Africa, and for that matter, I'm against the action, but for better reasons. 1, do you think the reason warranting a removal makes it legal in political sense? And do you think others like George Anda and Eslausu can be treated in the same manner when it comes to procurement? If your answer is yes, then there's a void of fairness in the execution of our law, causing chaotic clouds of panic and partisan slogans. Let's be honest, Charlotte Osei did well as a leader in an early acrimonious environment. Justice Osei. Hi, Bernard. I'm honestly biased. No, I think I just read this. Olanyo Nakwetia, the president would have done a suicide to this nation if he ignored to implement the recommendations by CJ committee. The law must be respected. The law must not be respected because of a person. It should be understood the EC boss fell on her own sword, and that caused her dismissal. That's Wolanyo Nakwetia. Kekeli Kofi Akpabli says, Bernard, you are not convinced by their argument. Tell them. And if they are truly espousing the true position of the law, then Ghana is in trouble.
Oh.
Okay. Incompetence, this is Eric Kusi. Incompetence is when a boss and your deputy, as a boss, your deputy goes on leave and you don't know. You are loggerheads with your immediate deputies, which adversely affects the commission. And then you go on to say some other things. Dampari Gampini says, it's a waste of time going to court. Find something productive to do. Charlotte is now history. Sam Kutu says, the EC reports also indicted the EC folks who wired EC money into their personal accounts. Okay, gentlemen, these are varied comments. The last thing I want us to deal with is, in the heat of this, 4 new Supreme Court judges are nominated. And 2 of them are members of the committee.
Then,
And I mean, this matter is going to the Supreme Court.
well,
I mean, you see, we are ordinary Ghanaians. People are lawyers. Does that not? Couldn't they have waited for this matter to be determined before they announcing two of the people who sat on this are now going to be on the Supreme Court?
The point is that we all know and we heard since January, these eminent persons had been nominated by the Judicial Council since January. And the notice that came up a couple of days ago or yesterday was the president giving notice to Parliament that the Council of State have also performed their obligation under the Constitution, whether to confirm, affirm, or reject the recommendation of the Council of the Judicial Council. And they have affirmed it. This was a notice to Parliament for them to also perform their function. It's not as if these personalities were nominated yesterday or because they served on the panel to... What about the others, the other three? But in any case, I mean, lawyers in this country generally agree that these personalities, even if you want to single out the two, they are persons who have distinguished themselves like their colleagues. And so who wouldn't want the best to be at the top of affairs in the administration of justice? But I want us to dispel that claim.
But you see, now, the truth is that in Ghana, it's not just law, but it's also politics.
But that is the problem.
So it shouldn't be the problem.
No, but that is the
You are
problem.
the people who say that justice must not only be done, but must be manifestly seen to be done. And sometimes unintended actions, innuendos, or mistimings can lead to people feeling that the decision is. So I'm not arguing a legal position. So you are looking at the timing, and don't forget, the population, a large majority of people, they only consume this based on what the newspaper tell them.
Bernard, in any case, who says that everybody disagrees with the committee? What about those who agree with the committee that the three personalities should be removed? I mean, already the chairperson or the chairman had recommended or acted on the recommendation of a state institution to suspend one of the persons who have been removed. What about that? You see, so let us not, in my view, I will not pretend that everybody is against their remover or the removal of one of them. What about the petitioners whose petitions were granted? Both the one who filed against the two and the one who filed against the one. Don't they also have supporters?
Martin, when we were in Legon, you were a politician. You were the JCR president of the Kwafo Hall. So you know a bit of politics.
Yes, I understand.
So legally, we haven't seen fault, but politically, could this not have waited?
Exactly. No, I think looking at it with hindsight, we should have waited. Yes, we should have
what
waited.
Should have been waited?
No, you see, the announcement that the process. Yes, it should have been. You see, there are certain things that no. You see, for the lay person, and don't forget, the country is so polarized. Okay, you know, again, amongst the two political parties. So as soon as you do this, it's further to the other side. So tactically, the timing was wrong. That one is unassailable. Tactically, they got it wrong.
Well, I totally disagree.
No, you see, you don't brush it in people's faces like that because you see
everybody's faces. What about the other person?
No, you should reckon that. You see, you should reckon that the country is polarized. You see, we have the
polarized also against commission of crimes.
Oh no,
against
I mean, let's not pretend. You see, if we do
no
this,
people commit robbery and others support them. Yeah. So we should just
no. I think when we do this kind of comparison, we'll blur the argument. He has Sicilian print. Perhaps we should have allowed some time to pass. And then,
do you know that there are vacancies in the Supreme Court which have to be filled?
Yes, so when? But you know the time.
But I like your bow tie, by the way.
Yes, after the time.
And I'll take it from you after the show.
It's as if I'm employed by City because the colors too much.
It's very nice.
Anyway, we started, so
you are a founding member. You
without
lawyer Ahmed Musa and lawyer. What's the name? I forget his name. David Annan. With McDonald.
Yes.
So the question today was whether the EC chairperson's removal was a question of law or a question of politics. In 7 questions, as it appears, it tilts more towards law than the politics. But Martin says we shouldn't ignore how
there's
people
no politics in it at all.
Yeah, we are not on the floor anymore. My guests have been lawyer Oppong, who thinks it's stricto sensu a legal issue. Martin Kpebu agrees largely, but thinks that we should be minded of the politics as well. My name is Bernard Avle. Thank you for staying with us and watching CCTV. There's a lot more coming up in the next hour. Please keep watching CCTV. Good night.